The court will now take up the case of Truehill versus the state of Florida. Counsel?
Thank you, Mr. Chief Justice. Good morning, and may it please the court. My name is Tracy Henry, and along with co-counsel, I represent Quentin Truehill. This case is before this court on the denial of a 3.851 post-conviction motion following an evidentiary hearing. Mr. Truehill's convictions and death sentence should be vacated because they are not supported by competent and substantial evidence. Truehill's counsel was prejudicially deficient in their representation and were not...
I apologize. I'm having trouble
Oh,
hearing
I'm
you.
sorry. Is this better?
That's a little better,
Can you hear me now? Truehill's counsel was prejudicially deficient in their representation and were not acting as the counsel that were guaranteed to Truehill under the Sixth Amendment. If the jury had heard the truth of the evidence and the full evidence, there is a reasonable probability that the jurors would have seen that the circumstantial evidence presented by the state was inconsistent with a reasonable hypothesis of innocence, or at least would have raised doubts about Truehill's culpability in comparison to his co-defendants. In this case, all of the evidence that the state used to connect Quentin Truehill to the murder of Vincent Binder was circumstantial. The prosecution relied on testimony regarding a series of uncharged collateral crimes and relied even more heavily on DNA evidence. In Claim 4 of our brief, we assert that Truehill's convictions and death sentence are unreliable because they're based on weak DNA evidence that should never have been heard by the jury, or at least should have been effectively confronted by defense counsel to expose the weakness of the DNA evidence.
Counsel, where can you point to as far as the DNA evidence that squarely places Truehill committing the murder?
There is no DNA evidence that squarely places Truehill as committing the murder.
And where was there testimony that there was DNA evidence that suggests that he committed the murder?
Oh, there's a great deal of evidence that suggested Truehill.
What specifically?
A great deal of testimony that suggested that. Specifically, regarding the DNA evidence, and the state relied heavily on this. One of the items of evidence was the machete. It was State 63, and everyone referred to it as the machete during the course of the trial. And what the jury heard regarding this machete was that while there was no blood found on it, the FDLE analyst found a partial DNA profile on the blade, a single source profile. She linked Quentin Truehill as the possible source of this DNA based on two locations. The state made much of this in closing, and they said that Livingston had found two genetic markers on the knife that matched Truehill, and this court even noted the same in its opinion on direct appeal. The jury yes.
The opinion on direct appeal said the DNA evidence places Truehill at the scene.
Yes.
Is that correct?
Yes.
So are you arguing today that it did more than that?
What I am arguing today is that this court and the jury did not hear all of the evidence, and what was in front of the court may have placed him at the... No, I'm not going to say that. What I'm saying is that neither the jury nor this court had the benefit of all of the evidence and had the benefit of the true understanding of the DNA evidence. While it may have appeared based on what was presented at trial that Truehill was at the scene.
Help me understand the role counsel might have played, given the concession you just sort of made.
Sort of. I'm going to walk that
back. To support some genuine hypothesis of innocence.
Oh, absolutely. Defense counsel had a myriad of failures, actually. First and foremost is that they hired a DNA expert that not only refused to testify, but refused to enter the courthouse in order to assist with cross-examination. And they knew this before they hired the expert. They knew that this was someone who was not entering the courthouse. What little advice that the expert did give them regarding the weakness of the DNA evidence, they ignored and did not bring it up on cross-examination. They failed to
your
obtain...
position is there's no tactical reason why they might have made that choice?
Absolutely no tactical reason whatsoever, and at evidentiary hearing there was no testimony as to why they hired this person, knowing full well that he wouldn't come to the courthouse other than the fact that they had worked with him before.
Let's say hypothetically that a piece of DNA evidence proffered by the state says, gives us a 1 in 1,000 chance to believe that a person was at the scene. And let's say hypothetically that your expert says it's actually 1 in 2,000. Defense counsel is barred. You want it to be the law that defense counsel is barred from calling that expert because whether it's 1 in 1,000 or 1 in 2,000, it could just be corroborative enough for the jury. We're not going to get into that. We're going to make some other argument. You think that kind of analysis is never tactical?
In some cases, that kind of analysis may be tactical, but in this case, absolutely not. One of the things that, in talking to the 1 in 1,000 and 1 in 2,000, that is actually a very important measure that was not addressed at trial. In DNA mixtures, pretty much all of the DNA evidence that was presented at trial, aside from the machete that I just mentioned, was a mixture, and was not just a simple mixture of 2 people, but more of a complex mixture, 3, 4, 5. We don't know how many people on some of these items.
Counsel, I'm gonna stop you for a second. You did a great job in your brief of laying out this argument. So let's say we accept that. Let's say we agree with you that there was this key point missing from this DNA evidence. It seems to me that the entire theory of defense here was never, and I think rightfully so, that he wasn't there. I mean, there were numerous situations where he was identified, he's on surveillance cameras, he's identified by the victims, he's in the vehicle where all of these items of evidence are, he's at the hotel room where they found even more evidence. I mean, was this ever, are you standing here arguing that they should have said he wasn't there at all, and that was their basis for their defense, and that's where they're deficient? Are you pointing to this DNA evidence for some other reason?
Bit of both. What we have with the DNA evidence, and I will accept your premise that we can throw away all of the DNA evidence. I will happily accept that premise. And what we are left with after we take away all of the DNA evidence is uncharged collateral crimes. Yes, inextricably intertwined, as this court found, with the murder of Vincent Binder, but nonetheless uncharged collateral crimes that cannot be used to convict him of this crime. It can be used for a number of other reasons, a mistake or planning or whatever else there is. But what the state did prove in the absence of the DNA was that they escaped from jail in Louisiana, Peter Hughes, Quentin Truehill, and Kentrell Johnson. They did prove that they stole a truck. They proved that Leanne Williams, who was one of the victims of the uncharged crimes, was robbed by these 3 men. They also proved that the person that did rob her was not Quentin Truehill, because she testified that the person who robbed her was bigger than her, and Quentin Truehill was not. They proved that Brenda Jo Brown was attacked, but again, this was not charged. Brenda Jo Brown did testify that she saw Quentin Truehill with a knife, but she doesn't know who hit her. She doesn't know who attacked her. She did not see that, so she was not able to say that Quentin Truehill was the person who attacked her. All of these are inferences that the jury needs to stack to determine whether or not Quentin Truehill was genuinely guilty of the murder of Vincent Binder. We have the testimony of Mario Rios, who said that Quentin Truehill grabbed him and brandished a knife. We also have the testimony of Mario Rios that he was very easily able to get away from Quentin Truehill. We have the testimony of Chris Pavlish, who said that, yes, Quentin Truehill grabbed her, but he also had skinny arms and he didn't really look very strong and was more interested in her purse than her. And aside from all of this that had nothing to do with Vincent Binder at all the state has as far as direct evidence, well, not direct evidence, circumstantial evidence of Quentin Truehill's involvement in this is that he did use Vincent Binder's credit card.
What about the knife?
Well, we have 2 knives, and different witnesses described different knives in Quentin Truehill's
What about
hand.
the knife I'm talking about the physical evidence of the knife?
The physical evidence of the knife. If we're talking about State's Exhibit 54, which is, that's the one that everyone referred to as the silver knife, and that is the knife that was determined to have been one of the murder weapons because Vincent Binder's blood was found all over it.
And there's no doubt about that.
There's no doubt that Vincent Binder's blood was on that knife, absolutely. Where there is a doubt...
Is there any doubt about where it was found?
No, it was found, that one was found in the hotel room, I believe, either that or the truck. But it was definitely found with the 3 co-defendants, yes. And the DNA evidence that was testified, the way that Quentin Truehill was linked to this knife, aside from Brenda Brown's testimony, was that there was a complex mixture on the cutting edge of the blade that could possibly include Truehill, Mr. Binder, Brenda Jo Brown, Peter Hughes, and Kentrell Johnson. And this inclusion was made on one location. And so what the jury heard was that Truehill's DNA was on what was clearly the murder weapon. But what the jury didn't hear is that a single location gives absolutely no weight to an inclusion, and that Truehill should not have been included on that knife. that the statistical values in the FDLE report, which was not entered into evidence, and the FDLE expert did not testify to these statistical values, was that the probability of exclusion from the mixture was 15%, which is a meaningless statistic because that means that 85% of the entire population could have contributed that DNA. And that according to the state's FDLE expert, DNA expert, Lee Clark, other than Vincent Binder's profile on that knife, any other information was too limited for comparisons. So what they're saying is, what the state is saying in closing is that his DNA is on that knife, and that knife killed Vincent Binder, but had defense counsel done what they were supposed to do, they would have cross-examined and shown how weak this was and that Quentin Truehill's DNA should not have been included on that knife. In a circumstantial evidence case like this, especially in the pre-Bush world, the state's not building a house. They don't have a solid foundation. They don't have eyewitness testimony. They don't have the defendant's DNA at the scene. They don't have video or eyewitness testimony or anything like that. What they're building is more like a pier. So they're putting up these posts. And in a case like this, which is very heavy, those posts need to be strong. And if those posts aren't strong, the case is going to collapse. What the state based their case on was extraordinarily weak DNA evidence, so we've knocked out those posts. So those posts are going to fall down. And then all we have left are people saying, well, yes, I saw Quentin Truehill do this, I saw this in his hands, but all of those require an impermissible stacking of inferences to lead to the conviction of the murder. In addition to that, well, the other point with this, and it's not the testing or of the DNA that's the results, it's the interpretation and the testimony regarding the DNA. And the fact that the defense counsel did not properly cross-examine or confront this evidence in any way. Jurors were instructed that what the lawyers say is not evidence. And what defense counsel did here was attempt to make himself the expert, because he knew that his expert wasn't going to testify. He attempted to make his questions to the FDLE expert the evidence that the DNA evidence was weak. But unfortunately, he did not understand the way that the DNA evidence was working. One, because he wasn't listening to his non-testifying expert, and two, because he didn't have anyone there advising him properly. Defense counsel has the duty to present this evidence, and in this case, it was necessary to do it through a testifying expert. The cross-examination was so ineffective here that Judge Zambrano actually had to stop the trial, call him up to the bench, and say, can you please stop confusing the jurors, the witness, and me? A testifying defense expert was vital, and without that, we can't have any confidence in the outcome of this case. And moving on to, I've got 2 minutes left. Regarding the fact that the DNA, and I do understand that we are talking about a felony murder case here as well. In argument 7 of our brief, we challenged the denial of a hearing on claim 9 of our 3851 motion, specifically the issue that both of Truehill's co-defendants received life sentences after he was sentenced to death. And as such, Truehill we should have gotten a hearing on this claim based on that newly discovered evidence. At the time of his sentencing, the jury and the trial court that sentenced Truehill to death had no idea that his co-defendants were going to get life sentences. And at the time of his direct appeal, while this court was still conducting proportionality review, the court took into account Peter Hughes' plea to a life sentence, but had not yet ruled in Kentrell Johnson's matter. And the decision of whether his co-defendants' life sentences require a life sentence for Truehill is fact-based. It should have been determined after the presentation of evidence regarding his co-defendants' participation in the crime and in the context of the facts. Rule 3851 states that at CMC, the court shall schedule an evidentiary hearing on claims raised by the defendant as requiring a factual determination. And this court has identified the failure to hold these hearings as a reason why there is a massive delay in the post-conviction process.
Doesn't our case law say that as a matter of law, when the co-defendants are receive a sentence other than death because they plead guilty or because of some other legal ineligibility for the death penalty, that's not going to be a basis for determining that the sentence in question should be reduced.
Well, our case law does say that, specifically, Judge Zambrano's...
It's not a factual matter, it's a question of law.
Well, in this case, we contend that it is a factual matter, because in this case, both juries found Truehill and Johnson guilty of first-degree murder, and the trial judge made very specific findings regarding his reasons for imposing the death sentence. In Truehill's sentencing order, the trial court found that Truehill acted under the substantial domination of another person. He found that it was proven by the greater weight of the evidence, but he gave it slight weight, and this mitigator was not raised in Kentrell Johnson's case. The trial court also found that Quentin Truehill and Kentrell Johnson's participation in the crime was on equal footing regarding the statutory mitigator of the crime being committed by another and the defendant having a minor role. The trial court found that this mitigator was once again proven by the greater weight of the evidence regarding Truehill, also gave it less than slight weight, but regarding Kentrell Johnson, he found that evidence scant and de minimis. And this was after the trial judge had the benefit of seeing the evidence in both Truehill's and Johnson's trials. And this court, in its opinion on Kentrell Johnson's direct appeal, noted that the trial court's sentencing order said that Johnson was older, physically larger than his co-defendants, and that his role was a prominent one. There was also testimony that Johnson gave his younger co-defendants instructions and appeared in charge of the group.
Okay, counsel,
yes.
you are consuming your rebuttal time.
In which case, I will reserve the remainder of my time. Thank you.
Good morning. May it please the court. My name is Patrick Bobek and represent the state in these cases. I want to start with Claim 4 on the DNA evidence. Each one of the claims in Claim 4 attack the DNA evidence of complex mixtures. This case is not built on the DNA evidence of complex mixtures. It's built on much more substantial evidence than that, including 2 full DNA profiles of 2 of the victims. Vincent Binder's blood and Brenda Brown's blood are found on jeans in the hotel room that the defendants were staying in. Full DNA profiles of a single subject, not complex mixtures. Also, as to the machete, now this is a partial single source profile, and it excludes both co-defendants as a contributor and includes only Quentin Truehill as a possible contributor. And the jury was allowed to hear the statistical value of that match, and it was 1 in 190 African-American males, which is not the strongest evidence in the world, but remember, this is a knife found in the hotel room that matches the injuries that Vincent Binder received when he was murdered. In addition, there's a lot more than DNA evidence that connects them to these collateral crimes. Remember why the DNA evidence was introduced: to connect them to these crimes and Binder's kidnap and murder. We have the testimony of Brenda Brown, Chris Pavlich, and Mario Rios, who all said they were approached by 3 black men who accosted them. 2 of those people were accosted in Tallahassee on the same day Vincent Binder went missing in Tallahassee. Leanne Williams' ID card is found in the truck that the men stole and was recovered in Miami. Chris Pavlich's ID card, her social security card, and her high school diploma are found in the truck that the men stole. So this is not an evidence built on DNA. The DNA evidence, while helpful in this case, if anything, was the weakest part of the case. And so I think the court can ignore the science and the SWGDM guidelines and SOPs and jump straight to prejudice on this issue and see that there is none, because there's no reasonable probability that the outcome of the case would have been different had the complex mixtures been excluded or discounted by the jury. As to the co-defendants' life sentences, as Judge Kennedy pointed out, these were for legal reasons. Peter Hughes pled guilty, and Kentrell Johnson essentially had tried to plead guilty beforehand by making a deal with the state that he would lead them to the crime scene in exchange for a life sentence. The state reneged on that deal, and this court on appeal upheld it. So those are both legal reasons, non-factual, non-relative culpability reasons. And for that reason, relative culpability is not an issue. If there are no other questions, I'd ask that you affirm the trial court and reject the habeas petition. Thank you.
Thank you, counsel. Rebuttal.
I appreciate counsel's throwing out all of the entire DNA evidence. But just to correct a couple of things as far as the genes that the Vincent Binder's and Brenda Jo Brown's blood was found on, and that, yes, Quentin Truehill was possibly part of a mixture on the inside of the waistband. The probability of inclusion of any of the co-defendants plus Shirley Marcus on that one was 1 in 24 African Americans. One of the other things that wasn't brought out in front of the jury is that when a DNA analyst does these calculations, one, there has to be all of the evidence there. And in a lot of these, the evidence was weak. This was touch DNA. Touch DNA is not as strong as blood DNA. It is possible for the alleles to drop out. Once the alleles drop out, a DNA analyst cannot be confident in what they're finding. The probability of inclusion on this one was 1 in 24 African Americans. If you look at another thing that FDLE analysts
So counsel,
do,
these genes, I mean, was there any doubt that this was Mr. Binder's blood on the genes?
no doubt that Mr. Binder's blood was on
Is
the
there any
genes.
doubt these genes were found in a room occupied by Mr. Truehill and 2 other people?
In a black plastic garbage bag in a room occupied by Mr. Truehill and several other people.
So even without the DNA, I'm having a hard time drawing where the prejudices from really the testimony saying it could have been Truehill's DNA on this, or it could have been some other people's DNA, which is what the testimony was. I mean, where is the prejudice there?
The prejudice here is that what the jury continued to hear over and over and over again was that Quentin Truehill's DNA was on these items that were associated with the murder. Yes, Vincent Binder's blood was on there, but was Quentin Truehill's DNA on those genes? We don't know, because the levels were so low as to put them in the stochastic range, so that he should never have been included on these. And in fact, Lee Clark of the FDLE said that she didn't know how any part of those genes could have been considered probative because they had been cut up so badly. Where we have the prejudice is essentially the fact that 3 men participated in a series of crimes, and we don't doubt that, we cannot dispute that, but 2 of them got life sentences and 1 of them got a death sentence. And the main reason why Quentin Truehill got a death sentence is because he went to trial first. Kentrell Johnson knew how to game the system. He tried to plead guilty. He made a deal. Peter Hughes raised the specter of ID, and so that kind of could complicate his case. The way that Quentin Truehill's death sentence came out was arbitrary and capricious because he went to trial first. He had the lawyers that he had. He did not know how to game the system the way that Kentrell Johnson did. And in that case, we have to see whether the fact that because of all of these problems and all of these things that his attorneys failed to do for him leads to the fact that this is an arbitrary and capricious imposition of the death penalty and doesn't pass Eighth Amendment muster, and this court should reverse the death sentence and his convictions, or at the very least, remand for an evidentiary hearing on the relative culpability issue. And unless the panel has any questions, I thank you.
We thank you. We thank you both for your arguments in this case today. The court is going to remain on the bench. Counsel may retire, but the court's going to remain on the bench while I make a presentation to one of the people who serve our court. So. And I'd like to